Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Vicky Smolyar talks about influencer agreements and upcoming FTC regulations. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. I'm here with my friend Vicky Smolyar. Vicky, how are you today?
I am excellent. Thank you, Mike. How are you?
I'm good. I'm excited because we're going to talk about a contract that is relevant, honestly, to me and to some friends of mine. I'm going to show this to the folks at home. This is a brand influencer agreement as between Seattle Gummy Company and Rando Bob, whoever the brand influencer ends up signing this thing. So, Vicky, what is this document? When are we going to see this kind of thing in the wild?
So this is our brand influencer agreement. This is, content marketing has become a huge thing in the last, I don't know, let's say 10 years, right? Everybody wants influencer marketing. Brands, they feel more comfortable selling through people. They realize that people buy from people, not from large brands. So you have these influencers who have built these large followings. And so the brands are going directly to these influencers and they're basically like, sell my product because people will buy more that way. And so
Yeah, I was listening to a podcast recently, and they said there is no content marketing anymore. It's only marketing, right? Like all of these activities are becoming standard. But that means you're seeing a proliferation of these documents. You're seeing a lot of these out in the wild. And for reasons you're about to cover, we may need to be careful with it because this is a regulated space when you do these sort of public pronouncements about products. So let's go through it. We're going to dig into the actual document and kind of go point by point. I'm going to start at the beginning under services. If you look at 1.11 and 1.2, I'm going to read 1.11 a bit. Brand influencers shall provide at least 2 posts per month on social media channels on each of Instagram, Facebook, and Twitter. You must include the company product, its packaging, which should be clear, in focus, blah, blah, blah. We want to see that you're out there, and in 1.2, it's titled Performance. It sort of solidifies this, but it's setting out expectations for how often you have to talk about us. What are you seeing in this section, and what makes you nervous about this, overlaying it with the regulations?
So let me just talk about what the regulations have been and the direction that they're going in. So right now, the way that it has been, the FTC has one general act. The FTC is the body that basically oversees this space. They have one law, the FTC Act, and they have one section of this act that has this one general prohibition on deceptive advertising. What does that mean? Basically anything they want it to mean, right? So they have put out every several years, every 10 years now, these guidelines, right? So that people can go in and they can see what have we had issues with in the past, what are, what's going to be problematic. But those are guidelines, they're suggestions, right? And so generally, if you follow those guidelines, you're kind of in the clear. What are they doing now? Because how have they enforced this in the past? They have to go to court. That's a lot of resources, right? Like to go every single time to federal court and be like, we think this is deceptive. So they're going to go after the Amazons, they're going to go after the publishers, clearinghouses, because, the deep pockets. The smaller folks, largely unaffected, and I want to say largely because some of them have been in really egregious cases, they have gone after them. What are they doing now? They're like, enough of these guidelines. Let's codify this stuff because now it's going to be easy. We're going to have these bright line rules and we're going to say XYZ is bad, XYZ is illegal. And guess what? You violate that very clear bright line rule, $55,000 per infraction, right? We don't care. You're big, you're small. We don't care because now we don't have to present our case in federal court every single time. Here's the law. It says it's wrong. And so they have these proposed rules. The period on when to submit comments is closed last year, so they're now working on putting this into action. And I said this to you, I say this to all my clients, as long as we have an FTC in November, this is going to be the new landscape, right? Like you're going to have these rules and you're going to have to play by them, and you're not going to play by them, you're going to get a nice little letter from the FTC in the mail. And they've already done this, right? Especially with in the influencer space, they sent out like 700 letters to like some of the major influencers a couple of years ago, trying to like scare them into compliance. Nothing really like came out of it. I mean, they were like spooked, and we talked about it for about a minute, and then it kind of just like went away because again, they're not going to go after the chump change. They don't have the resources for that, but they will. But they will, right? So this is concerning to me when you have a brand, right? And this is a very specific brand because this is also like they're selling gummies, and they're selling gummies that are, they're making health claims about these gummies. Like if you go, especially to their website, they want to tell everyone that they give you energy and they give you this, and there's so many rules around making health claims. But aside from that, this is a brand influencer agreement. So you have somebody who's making an endorsement on their behalf about how effective these gummies are or what they're doing with these gummies, right? Like they have all these things here, like how they want this to be presented.
Yeah,
And
yeah.
they're,
Let me point to that real quick because I think it's interesting. So you've got those requirements about when to post, but it specifically says themes to post should include fitness, such as running, yoga, etc., lifestyle, such as travel days, road trips, etc., and mom energy. I'm assuming that mom energy means that if I'm taking this CBD gummy or whatever this thing is, that I'm going to have more mom energy. That's a representation.
Correct. That's exactly right. And then, I'm looking at this right now. Like they're like, here are the hashtags that we want you to use, right? Like this is clearly an endorsement, right? So there's a lot of rules around endorsement. The main ones being that you have to have all these clear and conspicuous disclosures about what your, relationship is with the actual brand. You can't pay them to give you positive reviews, which we'll talk about in a second. This is the other part of this contract that bothered me. And so they have these little hashtags here, and I'm looking at these hashtags, and none of these required hashtags have anything to do with the endorsement and the hashtags that the FTC clearly requires you to disclose, right? So if you've ever been on social media and you've looked at some of these things that influencers are doing, you'll see that if you read and you click into the actual meat and potatoes of the post, not just what they're saying in the video or on the image, if you click into the images, all the way at the bottom, sometimes you'll see hashtag ad, and they think that that's enough, right? And now a lot of these social media platforms have actually also included native features in their platform to allow people to make that sponsorship connection. And the FTC is like, no, that's not enough. Like it has to be clear and conspicuous, right? So if I'm doing a video and I'm talking about how much mom energy I have from these gummies, there better be some disclosure on the bottom that's like, this is an ad. Like, this is my actual opinion. This reflects, like, if I'm paid for it, it's got to say I'm being paid for this opinion, right? I can't go and, actually be falling asleep from these gummies, but be telling all my followers that it's giving me all this mom energy. That's false and deceptive.
Right, but
And yeah.
what I want to think about here is the drafting exercise, and so I'm to tie into that. I'm going to point back to 1.2 where it talks about performance. If you look at the list of things that they have to, it says you cannot, you the brand influencer, you can't mislead, lie, misrepresent the company. You can't disclose third-party confidential information, and this is the one that I think is really interesting here. It says you cannot misrepresent the relationship between company and brand influencers. I think what you're leading to is you think that the brand should explicitly say, no, you need to represent, you need to say explicitly what the relationship is. As a drafting exercise, would you put that into a document like this, that requirement?
Absolutely. Absolutely. You would have 10 riders, 10 attachments to this that'll say this is exactly what you have to post because the onus is on the brand, right? Like here they are in 1.2. I think this is what you were reading, right? You can't misrepresent. What does that mean? How would an influencer with no experience in law, because I'm telling you right now, very few of them have legal representation. They're literally just looking at these things and signing on the dotted line because the money they're getting is so little. How are they supposed to know what the applicable laws, ordinances, rules, regulations, orders, licenses are? That's not on me. That's on you. You're the brand because guess what? The FTC is coming after you too. Like you can't just contract around this obligation, right? So you better go in there and you better know exactly what's supposed to be said. You have to know what the laws are. And then you have to explicitly tell this influencer, this is what you got to tell people. Like, we're going to be above board here. This is what needs to be said. These are the disclosures that need to be made. This is how they need to be made. If you're making a video, it's got to appear here. It's got to be clear and conspicuous. If you're posting just, a picture and you're doing a caption, the first thing in the caption has to be this hashtag that clearly ties me to you and you to me. And we're not going to rely on the native features of the platform because they're not that reliable. Like, nobody wants this problem, especially once this gets codified. Like, this is going to be, they're going to find the influencer who doesn't have the money, right? Like, we all know, like, can't draw blood from a stone, but they're going to find them anyway. And then they're going to go after this brand.
Yeah, and the context for this, for those of you who aren't familiar, some of these brands, I mean, they have 400 brand influencers that they're paying. There are platforms that will help manage this slew of brand influencers. And if you're paying those brand influencers $500 or whatever, that's a lot to that brand influencer. To the company, that's not very much. And they can do this 1,000 times and still run that budget. So theoretically, back to the drafting exercise, you would think maybe you could make an argument for very broad general statements that will work for everybody, but I'm going to jump to 1.1.2. And all it says, listen to this short sentence, all it says is brand influencers shall provide for mentions of company product in stories each month. That's all it says, nothing about the substance of what they can say. What do you think about 1.1.2?
Well, this goes back to, especially in this situation where you have a gummy company that wants you to talk about mom energy, right? Like, that's the paragraph right above this. And it's like, well, okay, so am I going to go and tell people that this makes me energized, that this gets my levels up, that, all of these claims that the FTC is just going to come down on you with like the force of 1,000 suns, right? Like, because the health claims are the things that they take very, very seriously. And they have to be very substantiated. You can't just go out and be like, like, this was the big deal with like the weight loss teas. That's when they came down on all those influencers. They were pushing all these like weight loss teas. And they were like, no, 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 no. You have to have studies. You have to have, like, this really needs to be substantiated. And then you can't just disclaim your way around like these health claims. Like, you'll disclose the health claims, then you'll put a little disclosure that says, oh, no, 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 but we don't really care about that. Like, or I'm just going to say whatever I want to say. No, you can't do that, right? It's very, very specific about what can and cannot be said, when it can and cannot be said. And so for you to leave it this vague and not define and not at least give, a bulleted list of what's cool, what's not cool, because you can't rely on the influencer to know this type of stuff, right? Like, these are mom energy. Like, moms are going to wake up, like at 6 o'clock in the morning, disheveled. Like, they're not thinking about like, what claims should I make? They're like, I'm going to pop this gummy. Does this give me energy? I'm going to tell everyone about it, right?
Right, which is the energy that they want them to have. All right, speaking of short
Correct.
sentences, once upon a time, we did a whole episode about online giveaways and the rules about it. I'll link to it over at lawinsider.com/resources, but I'm going to read a sentence. This is 1.1.3. Brand influence. By the way, we'll give you the link to this. You should find all the typos. Lawyers love some typos. But anyway, brand influencer, I assume is what it's referring to. Yeah. Brand influencer must provide one giveaway of company product each quarter. Giveaways are complicated. This is a short sentence. What do you think?
Yeah, this gave me hives. I'm not gonna lie. This is this is just sloppy. Like, here's the problem with this, right? Here's the problem with this. Um, I assume this was written by an attorney, but this is freely available on the internet. This isn't just available through Law Insider, where, people like you and me and other contract drafters can go and look this up. This was actually also freely available on the internet. What does that mean? That means that smaller brands that don't know better go online, they type in brand influencer agreement, and they download this, and then they use this. And now we are creating this like web of nonsense that's about to hit. And then like people that come to me with this, when this dumpster is on fire, I'm like, oh man, why did you do this? Right? So, one sentence: sweepstakes are so complicated. Aside from the fact that the FTC has their own rules around how you can and can't do sweepstakes, and that requires like a laundry list of terms and conditions about like, when the giveaway is, what the affiliations are, how do you claim your prize. But it's also done on a state by state level, right? So like every state has its own sweepstakes rules. If you're giving away something worth more than like $50 somewhere, you got to go and you got to register with the state. And if you're doing this online, you're reaching probably 50 states, right? So you got to have registrations in like all 50 states. Each platform that you're doing the sweepstakes on also has their own rules about sweepstakes, right? So you have one sentence in this agreement about something that is massive, like that affects federal, state, platform, like how am I the influencer? Again, I'm getting $200 for this, whatever. I'm
Right.
supposed to know. Like I'm just gonna be like sweepstakes, done, right?
Right.
I've checked off what I have to do. Like if from a drafting perspective, like not even from a drafting perspective, I think even from like a practice perspective, aside from the fact that this obviously needs to be more robust and there has to be limits about how this is run and whatever, again, the onus is on this brand to create a terms and conditions that you can point your influencers to that say, when we do sweepstakes, this is how we do them, right? If you are going to have the same sweepstakes for every single influencer, which I'm assuming this does because this is just, one agreement for everybody that they use, at least at the very minimum, you could be like, here's the link you got to link to. Here's what people have to do to claim their prize. Like we've already registered in all the 50 states where this prize could have potentially been won. Like, and here's what you have to tell people when you're running the sweepstakes, not like provide one giveaway of company products.
Yeah, speaking of what you have to say, this is super. So in the contract, if y'all are looking at it, it goes through how much money you make, what the term is, confidentiality, those things. But I want to run down, since the theme of this is talking about these FTC overlaps, I want to run you down to 12. It's titled non-defamation. I'm going to read a bit of this. Brand influencers shall not, during the term of this agreement, nor at any time thereafter, directly or indirectly, in public or private, in any manner or in any medium whatsoever, deprecate, impugn, or otherwise make any comments, writings, remarks, or other expressions that would or could be construed to defame, to be negative about the company. Listen, if you're hiring me to go and give a review of your product and I think your product is terrible, this is telling me I cannot go talk about how terrible you are. What do you think of this section and that overlap with the FTC rules?
That's exactly why I flagged this. I was like, I don't know why you would put this into an influencer agreement when the rules are so obvious about, being open and honest, right? And there's has been a consistent problem in the marketing space, right? This is why these guidelines exist. This is why the FTC is looking to codify this stuff, right? Like there, companies have filtered reviews, they have put out fake reviews. And so now the focus is right because what happens when people see these fake reviews or these filtered reviews, that induces the consumer to make that purchase, right? So that's what the FTC is really concerned about here. Like, is this deceptive? And if you're telling me out of one corner of your mouth that I have to go and I have to be honest because that's what the law says, but then on the back end, you're putting in something that says you can't talk, you can't say anything bad about me. Well, how is this going to be enforceable? First of all, in any court of law, but like as an influencer, as somebody who's arguably read this and didn't just blankly sign it, I wouldn't know what to do. I would think that I'm obligated not to be honest. Like if I don't like this, if this stuff made me fall asleep, I can't tell people about it because you're going to come after me and be like defamation. I mean, this is also a
Right.
really weird way to put this, but whatever.
Yeah.
That's just semantics. Yeah, no, I don't know how this would hold muster in any court of law.
Yeah, and I mean, this limit on what you can say out loud, part of it is in the context of the brand themselves are a regulated entity as well. And so there are risks. And as with any contract, both sides, they're trying to slough off some of the risks on
Sure.
to the other party. They do that a lot with the indemnification section, which we've covered many times. I'm going to jump down to this contract. It says brand influencer will indemnify, defend, and hold harmless company with respect to any and all causes of action, claims, demands, damages, costs, suits, liabilities arising out of in any way related to the influencer's interaction. There's no cap on these things. There's not a lot of rules about these indemnifications. It's basically this company saying, bro, this is your fault while we're not giving you much guidance. What do you think about this indemnification section?
First of all, I have a really big issue with the way that this is worded, because we're attorneys. We know that words matter. We know that, I love that they have in this agreement, that no party will be deemed the drafter. So they snuck that little bit in, like, we're going to screw this up, we're going to write whatever we want, but we're not going to be held responsible for that, right? Like, you can't interpret this against us. But this is like, okay, in any way related to the brand influencer's interaction with a third party that is not due to the defect of the company product. So it seems like they tried to narrow it down just to defects, but then it's any interaction with a third party. Like, what does that even mean? Is me posting online to my followers, is that considered an interaction? Like, how do you define that, first of all? Second of all, like, you can try to indemnify, right? And you can try to use this indemnification clause. But here's the thing. The FTC is very clear about this, right? They're like, advertisers, you are responsible for all implied and expressed claims, right? So it doesn't matter that you have this indemnification where you're like, to give you guidance, like, you got to figure out what the laws are and you got to comply by them, and we're just going to indemnify ourselves, we're going to carve ourselves out from any and all liability with this weird indemnification clause. No, that's not going to be enforceable. Like, you can try. That's not going to, the FTC is going to be like, cool, $55,000 per
Yeah,
infraction.
nice words. Well, as I think in wrapping this up and thinking about the context, I'm wondering who should have the onus to figure this out. Because if you're a brand and you've got 400 of these relationships and a platform you're working on, well, then, the incentive and the leverage, the capability is there to go get this right on your end. If you're the influencer, you might have 10 of these deals, right? You might be making a couple thousand, few that to go use your mom energy to buy Stanley Cups or whatever people do with their money from this stuff. For you don't have that leverage. You don't have that capacity, but you could be on the hook. What's the FTC doing here? Is it trying to put the kibosh on these brands and say, hey, no, we're going to hold you accountable? Or is there real risk to the influencer that they should be paying attention to and dealing with as well?
So like I said, right now, when it's just guidelines, right? Like, they've tried to go after the influencers. They went after, like, the Khloe Kardashians, the
Right.
ones they know that are going to pay. Um, Listen, are they likely to go after, Samantha, the mom influencer from Seattle who takes these gummies? And probably not. But now that they want to codify this stuff, I don't know. They're like, we're here to protect consumers. That's our number one concern. Is that their number one concern? Oh, I mean, it seems like a revenue raising operation to me. But I digress. Like, sure, they're concerned with the consumer. They don't want random moms to go and drop, $50 on gummies that don't actually work when Samantha, who's promoting them, doesn't actually think that they work for her, right? Like, there is this level of concern for the average Joe consumer. So, once they have this stuff codified, will they be making examples out of people? Yeah, they will. And I think, like, I understand that you're a small time influencer, you don't have the money, but then you got to be more discerning about who you're working with, right? And then you got to look at this thing. And if this looks fishy, right? Like, I don't think I need to be an attorney to look at this and be like, if you're going to tell me I got to provide sweepstakes, like, maybe you should be a little bit more specific about what I should say, what I can say. Like, this isn't really enough. Like, right? Like, you're still a business if you're an influencer, and you got to think like a business person, right? Like, you can't just be like, you know, I wash my hands clean, it's all going to be on the brand, because I don't think it will be. I think that they're going to make some examples out of people. And then, because it's not right now, nobody's paying attention to it because it's not in the news, because, there's no urgency to it. And people aren't going to be like with many other things, people aren't going to be paying attention to any of this legal stuff until the dumpster's on fire.
Right.
And then they're gonna be like, oh my God, what did I do? Right. And so
Yeah.
that's kind of like where I'm telling my clients, where I'm like, guys, we can't play this anymore. Like, we got to take this seriously.
Yeah, and it's, I'm in this world, right? Obviously, with the role that I have. And as far as I know, there's not some kind of trade organization or something. And it feels like when you're talking about these very micro players, that's what you do. A bar association in the non-mandatory bar areas, or, medical has a lot of advocacy groups and whatever. You see these things. As far as I know, if we're going to do this, if we're going to have these massive, new exercises, and the FTC wants to regulate and they want to go after sort of the supply side, we should organize, right? We should get people to come and create larger organizations that have the leverage to look out for this stuff and create standard contracts. But that's certainly not happening yet. You see in his documents all kinds of typos and randomness, and I appreciate you bringing to us. It adds a lot of context. For people who want to reach out to you and talk about contracts like this, what's the best way to contact you, Vicky?
I am on LinkedIn. So just my name, Vicky Smolyar, and LinkedIn. I am on Instagram at trademark attorney Vicky, because that's what I handle, all the brand stuff, trademarks included. And I talk a lot about this stuff. So if anybody's interested in, if you're, in the influencer space, even if you're an attorney who drafts for influencers, because I have a lot of, we're a nice close group.
Well, we will put your contact information and this contract over at lawinsider.com/resources. And if you want to be a guest on the Contract Teardown Show, just email me. I'm at community@lawinsider.com. We'd love to have you on. Vicky, thank you for joining us, and we will see you all next time.
Awesome. Thanks, Mike.
Thanks so much for tuning in to this episode of the Contract Teardown Show from Law Insider. If you're enjoying the show, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show. We really appreciate it. Thanks again for listening, and we'll catch you in the next episode.